the head of Holland and Hart's Health Law Group. We're here today to talk about Idaho's new Parents' Rights in Medical Decision-Making Act. This is the new act that came out that basically requires parental consent for all unemancipated minors. We'll talk more about exactly what it requires. As far as a couple of housekeeping matters, as far as written resources, you can access a copy of Senate Bill 1329, which is the statute, at the links up there on your website. Also, the statement of purpose is important. You can access that at the link up there. I did an article on this that you can also access if you want a little bit of information. All right, what does the act cover? Well, effective July 1st, 2024, the statute states that you must obtain parental consent to treat unemancipated minors with limited exceptions. In addition, not only do the parents have a right to make healthcare decisions for their minors, they've also got the right to access the unemancipated minors' records, again, with very limited exceptions. If a healthcare provider violates those rules or a parent's damaged because of it, then the parent can go ahead and sue the provider and recover their damages. Importantly, according to the statement of purpose, that act is intended to supersede any current provisions of Idaho law that may otherwise conflict with the act. So that's a quick summary of what it requires. Now I'm going to step back a little bit and just talk about the legislative process. This is a good example of a statute that kind of got ahead of steam, came relatively late in the legislative session, and basically passed before people could really take a close look at it and raise concerns with it. I reached out to some of my colleagues who dealt with this, who deal with the legislature, and one of them explained to me that the stakeholders in this process were not consulted when the legislation was introduced. The legislation, they actually discovered it during the print hearing. Conversations with friendly legislators weren't resonating. It was very difficult for them to understand those negative consequences, the things you as healthcare providers you could recognize. The legislators just didn't think about it. As the lobbyists and the others who represented the industry heard many times, parents have, according to the legislator, parents have a right to know. And it was hard for them to help those people understand the side effects of this statute. To make, I think partly that contributed to the passing of this, the legislation was routed through the judiciary committees in both the House and Senate, which kind of took a different route. So it limited their ability to provide education or raise concerns about the particular statute. And as a result, the statute passed through both committees and the floor along party line votes with an overwhelming majority. Because of that, even though concerns were raised to the governor's office, I think that the governor's office felt like there was such a huge majority there maybe wasn't much that they could do about it. So the bottom line is we've now got this statute on the books and we've got to figure out, okay, what does it mean and how do we implement it? It does become effective July 1st, 2024. Okay, let's talk about each one of the elements. The first is the patient's right to consent for minors. The statute actually says that except as otherwise provided by a court order, an individual shall not furnish a healthcare service or solicit to furnish a healthcare service to a minor child without obtaining the prior consent of the minor child's parent. That's what the legislation actually states. The statement of purpose confirms that consent for the furnishing of healthcare services to any person who is an unemancipated minor must be given or refused by the parent of such a person. Now, a couple of interesting points. Note that it applies to an individual should not furnish a healthcare service. It's not just limited to healthcare providers. I'm not sure what other individuals they would decide to go after, including Good Samaritans or whatever, but it's an interesting choice of words. Note also that it requires that you obtain consent for the minor child's parent. That's singular. It doesn't say parents, so probably you only need consent from one of the minor's parents. As I mentioned, the statement of purpose, it doesn't appear in the statute itself, but the statement of purpose states that it's intended to supersede any current provisions of Idaho law that may otherwise conflict with the act. What does that mean? Well, apparently it nullifies all those other Idaho statutes that we've been dealing with and that we're very familiar with where minors could consent to their own care. For example, exams, prescriptions, devices, and information regarding contraception. Now, apparently, this statute trumps that. Treatment for certain infectious or communicable diseases, including STDs, hospitalization for mental illness, treatment or rehab for drug abuse, blood donations, abortions in the case of rape or incest by certain family members. All of those other statutes in Idaho that would have allowed minors to consent on their own behalf, it appears now, at least by this statement of purpose, that all of those are preempted. And if you've got a minor, then you generally need to get a parent consent unless you fit within one of the very limited exceptions. Now, it applies to any kind of healthcare service. Healthcare service is defined extremely broadly. It's a service for the diagnosis, screening, examination, prevention, treatment, cure, care, or relief of any physical or mental condition, illness, injury, defect, or disease. I can't really think of what you might do that doesn't fit within that definition. It seems to be fairly all-inclusive, and it includes probably not just prescribing or diagnosing, but even counseling concerning healthcare issues. Certainly it applies to not only physical issues, medical issues, but also behavioral health issues. I mean, this will be certainly a big change for a lot of our mental health care providers who have kind of this rightly or wrongly placed belief that they can't discuss what a minor tells them with their parents, or that minors can consent to their own care. This is certainly a sea change. Now, it only applies to a minor child, and minor child is defined as an individual under 18 years of age, but does not include an individual who is emancipated. So if the minor is emancipated, then this statute does not apply. Now, the statute itself does not define what emancipation means, but in other Idaho statutes, they identify emancipation. Generally, we think emancipation means the following. Either the minor's gone to court and the court's declared the person to be emancipated, or the minor is married or has ever been married, or they are serving in the active military, or probably if they are living on their own and are self-sufficient, have rejected the parent-child relationship. There's case law out there that would suggest in those situations the minor should be considered emancipated. Importantly, pregnancy itself is not an emancipating event in Idaho. We know that because the abortion statutes generally require parental consent for if and when, in those rare cases, abortion is legal. They require parental consent. If pregnancy were an emancipating event, then anybody who became pregnant would be emancipated, and therefore there would not be an unemancipated pregnant minor, as stated in the abortion statute. So pregnancy itself is not an emancipating event. Well, if you've got an unemancipated minor, then you generally need to get the consent from the parent. Who is a parent? The statute defines parent as the biological parent, an adoptive parent, or an individual who has been granted exclusive right and authority over the welfare of a child under state law. Well, that's pretty easy when it comes to biological parent or adoptive parent, or even the court-appointed guardian. But what does this mean to have the exclusive right and authority? Does that mean that if Department of Health and Welfare steps in and assumes authority, do they have the exclusive right and authority? If the parent's rights have not been terminated, does that mean that you can act on the authority of health and welfare, or do you still need to get consent from one of the parents? What about a grandparent or foster parent? If the parent's not available, under the old hierarchy in 39-4504, there's a hierarchy of who could give consent. What about those people? Well, they probably don't have exclusive right and authority, so you may not be able to rely on that anymore. Instead, you need to try to get the consent of the actual parent. It's not a step parent. They're not a biological parent or adoptive parent. So they wouldn't suffice either. They probably don't have exclusive authority, and therefore, again, you've got to try to get the consent from the parent. Now, there are exceptions to the rule. You're not required to obtain parental consent if the minor is emancipated, because they're not considered a minor under the statutory definition, or as otherwise provided by a court order. So if a court orders you to go ahead and provide care, or allows you per the court order to provide care without the minor consent, then you can rely on that. Of course, that doesn't happen very often. There are a couple of other exceptions. Perhaps the most important is that you're not required to get the parental consent if a parent of the minor child has given blanket consent authorizing the healthcare provider to furnish the healthcare service. And we're going to come back and talk about that blanket consent in just a minute. Another exception is after reasonably diligent effort, the healthcare provider cannot locate or contact a parent of the minor child, and the minor child's life or health would be seriously endangered by further delay in the furnishing of healthcare services. So note that there's two elements to that. It has to be an emergency, which you're all familiar with, but it also states that after reasonably diligent effort, you've tried to contact the parent. Well, what happens if the kid shows up there and it's emergency? You don't have even time to make a diligent effort to contact the healthcare provider. Then technically, I suppose there could be a violation of the statute, although certainly I don't think that's the way that it plays out. Okay. Now, what about other situations? What about if federal law authorized the minors to consent? Maybe the federal law preempts the Idaho state law, for example, under EMTALA. Under EMTALA, then generally at least the interpretive guidelines, if the patient shows up, a minor patient shows up at the hospital, and the EMTALA interpretive guidelines state that you can go ahead and begin stabilizing treatment or an appropriate transfer of the minor based on the minor's consent or under the emergency exception. But it doesn't say that you can't try to get the parent's consent or you shouldn't try to get the parent's consent. It says that you may initiate it while you seek to get the parental consent. Another issue is Title X programs. Under the federal government has taken the position that if you're a Title X grantee and providing family health, family planning services to minors, that minors could consent to that care and you couldn't disclose the minor's care to the parents. That's been HHS's position, the federal government's position for many years. However, just in March, just a few weeks ago, the Fifth Circuit affirmed a decision from Texas in which they said that Title X interpretation does not preempt Texas's parental consent law. And I haven't gone back to double check, but I suspect that may have been part of the impetus for passing the Idaho statute. So we'll have to wait and see how that plays out. At least on the Fifth Circuit, the Texas, the state law trumps any Title X interpretation by HHS. That may make its way up to the Supreme Court. Given the Supreme Court's recent rulings, we suspect that probably that would be upheld. And therefore, even in Title X programs, you would still need parental consent. But we'll have to see how that plays out. All right, let's go back to that exception, because under that exception, remember that if the parent or child of the minor child gives a blanket consent authorizing the healthcare provider to furnish the healthcare service, then you don't need to get specific consent, at least for that particular healthcare service. But that raises some questions about that blanket service. First of all, the statute, that exception refers to furnishing the healthcare service, not just any healthcare service, it's the healthcare service. So how broad can that blanket consent really be? Remember that the general rule is you still have to have informed consent in order for the consent to be effective. Under the Idaho statute, Idaho Code 39-4506, it states that the consent or refusal of consent for the furnishing of healthcare services is valid if the person giving or refusing the consent is sufficiently aware of pertinent facts respecting the need for, the nature of, and the significant risks ordinarily attendant upon such a person receiving such services as to permit the giving or withholding of such consent to be reasonably informed. So, in order to be effective, it's not enough that you have consent, the consent has to be informed. So that raises the question, well, if you're just going to give a blanket consent then, I mean, are you really getting informed consent? If a parent just gives you some kind of a consent form that the kid walks in with, the minor walks in and says, yeah, you can provide whatever care you think you need to my minor, is that going to be effective? Because is it going to be informed consent? If you haven't discussed the relevant facts with the parent, the risks, the benefits, the alternatives, then it may not be truly informed consent. And it may be a blanket consent, but it may not satisfy the standard for informed consent. The bottom line here is I think you better be very careful about using those blanket consents. I think a blanket consent may be helpful if you've got kind of an ongoing course of care, of course of treatment for the patient, and you're staying within the scope of that consent that you initially got. But if you're going to use that blanket consent to try to provide treatment for a bunch of different services to this particular patient without having discussions with the parent about the risks and the benefits, the particular circumstances of that episode of care or that particular condition, then I think that that's dangerous. Does that blanket consent form have to be in writing? Well, the exception doesn't refer to it. It just refers to a blanket consent. In the Idaho statute 39-4507, it states that it is not essential to the validity of any consent for the furnishing of healthcare services that the consent be in writing or any other specific form of expression. So theoretically, yeah, you could probably have an oral verbal blanket consent from the parent. However, you may have proof issues, right? We like it documented in order that you can, in order to prove that that consent was really obtained. The statute goes on to state, this separate statute, that if you do get it in writing, if the giving of such consent is recited or documented in writing and expressly authorizes the healthcare services to be furnished, and when such writing or form has been executed or initialed by the person competent to give such consent, so when the parent signs it, such written consent is presumed to be valid for the furnishing of the healthcare service and the advice and disclosure of the attending licensed independent practitioner, as well as the level of informed awareness of the giver of such consent. The bottom line there is, if you do get written consent from the parent, then it has this presumption that it's valid and sufficient. So if you are going to rely on these blanket consents, I'd suggest that you certainly get those in writing. Okay, well, what happens then with this statute that we've got on the books and we've been dealing with for years and years, right? That it stated that in the case of minors generally can't consent to their health care, but then you would look to this hierarchy of who can get consent. In the statute, the ones relevant to minors are a court-appointed guardian of such person, if they're not available, a parent of such person, if they're not available, then you can look to a person named in a delegation of parental authority. If they're not available, then you could get consent from any relative of such person. If they're not available, any other competent individual representing himself or herself to be responsible for the health care of such person, or if the person presents a medical emergency and there's substantial threat of harm, then the healthcare provider can go ahead and render care as if they had informed consent. Well, how does this work with the new statute? Well, again, if the statute says that if it's a minor, generally you have to get consent from the parent. The parent is the person with exclusive authority under Idaho law to provide that care. It would be the court-appointed guardian if that guardian has been appointed and has exclusive authority. Certainly it would be the parent, the biological or adoptive parent. But what about the other people? Well, the new statute really doesn't make accommodation for any of these other people. So if you're going to rely on consent from one of these other people, because they may not have exclusive authority, they may not satisfy. So don't assume that just because grandparent brings the kid in, the grandparent can consent. I think in those situations, I think you're probably going to want to get consent from the parent, because grandparent probably doesn't have exclusive authority. Now, note, however, that there's still that exception in play, right? That if the kid presents with an emergency and you've made reasonable diligence but can't find the parent, then you go ahead and provide emergency care. Again, do what's in the best interest of the child, document your efforts, and I think you'll be okay in those situations. I want to come back to this situation because one of these persons who does have authority, at least under 39-4504, is the person named in the delegation of parental authority executed under Idaho law. You may be aware of this, but the Idaho statute will allow a parent to delegate their power to make medical decisions for certain persons. General rule is it can be up for 6 months. It has to be through a properly executed power of attorney. Does that still work under this new statute? Well, we don't know because we haven't got any cases. I think it probably does, because the whole purpose of the statute is to make sure that parents are involved in the medical decision making for their minor. And if the parent wants to delegate that to somebody else, then they're probably going to be okay in that situation. But who knows? I think you're okay, but I guess we'll just have to wait and see how that plays out. All right, so the general rule is beginning July 1st, you got to get parental consent. Even in those situations there in the past, the minor could consent to their own health care. But what do you do in a situation if the parents refuse necessary care? Because the authority to consent is also the authority to refuse, right? Well, in those situations, you can't just ignore what the parent says. I guess your options are you could report child abuse or neglect. The definition of child abuse or neglect includes the parent who fails to provide required medical care for the child. So if you've got a parent refusing that care, then what you probably should do, you think it's necessary, I'd call Child Protective Services to explain the situation, tell them you're not sure whether it's child neglect or not, but this is the situation, and ask them if they want the report, and basically turn it over to Child Protective Services to handle. If Child Protective Services declines to get involved, then document that you did what you could. You fulfilled your obligations, document who you spoke with, what they said, when they said it, and make sure that that's in the record. Another alternative is the Idaho statutes do allow a healthcare provider to seek an emergency court order if the physician informs the court orally or in writing that in his or her professional opinion, the life of the child would be greatly endangered without certain treatment and the parent, guardian, or other custodian refuses or fails to consent. That's another option for you that you could do, but that's probably more problematic. Requires your some expense and the like. That probably the easier, better course is simply to contact Child Protective Services and let them step in and take over. The key there is that the statute affirms that you do not, as a healthcare provider, have the unilateral authority to step in and provide necessary care. That's generally, for right or wrong, that is the parent's right now. All right, so that's the rules concerning parental consent. Let's talk about the other portion of this, which is the parent's rights to access the minor's records. Effective July 1st, 2024, no healthcare provider or governmental entity shall deny a minor child's parent access to health information that is in such healthcare providers or government entities' control, and if it's requested by the minor child's parent. Again, the act is intended to supersede inter-contrary provisions of Idaho law. So in some of those Idaho statutes that would have prevented you from making disclosures to the parents, or those are all gone now. Those are presumably all superseded by this new statute. Importantly, that there's no retroactive application of this statute. I mean, there's nothing that accommodates care that was rendered before its effective date. So even though you provided care to a minor on the assumption that it was going to be privileged and confidential, effective July 1st, it appears that the parents would be able to access that information, even information that was concerning care that was provided before July 1st. There's nothing in the statute that states otherwise. And therefore, I think the safer approach would be to assume that come July 1st, the parents are going to have access to any of the minor kids' records, even if it was subject to confidentiality before July 1st. Well, unlike the Consent Act, this statute concerning parental access applies to healthcare providers. Healthcare providers are defined as a physician, healthcare practitioner, or other individual licensed, accredited, or certified to perform healthcare services or provide counseling consistent with state law or any agent or third-party representative thereof, or a healthcare facility or its agent. Healthcare facility is not defined in this statute, but in other Idaho statutes, it's defined extremely broadly. So again, I think it's intended and should be applied in a very comprehensive fashion. It's any kind of healthcare practitioner, counselor, any of those entities out there, then you've got to comply with this new parental access law. Well, it requires you to give the parents access to health information. What's health information? It's information or data collected or recorded in any form or medium, and personal facts of information about events or relationships. So it's not only you give them access to records under HIPAA, but you would also have to disclose other personal facts that relates to the past, present, or future physical, mental, or behavioral health or condition of an individual or a member of the individual's family, the provision of healthcare services to an individual, or payment for the provision of healthcare services to an individual. Again, very comprehensive. If it relates to this minor's healthcare or payment for their healthcare or their condition that they're having, then I think that it's covered by the health information. Now, there are certain exceptions that would allow a healthcare provider to decline to provide parental access, but it's very, very limited circumstances. They may deny the parent access if the minor is emancipated. Again, they're not a minor then under the statute if they're emancipated. Also, the statute states that the parent's access to the requested health information may be denied if it's prohibited by a court order. Well, that makes sense, but that's not going to happen very often. Or if the parent is subject to an investigation related to a crime committed against the child and a law enforcement officer requests that the information not be released to the child. So there's another exception, but note how limited that is compared to the existing law. It only applies if two elements are satisfied. First, the parent has to be subject to an investigation related to a crime against the child. It's not just that it's not in the child's best interest or you think the parent may be an abuser. It's that the parent is subject to an investigation related to a crime committed against the child. And the second prong, a law enforcement officer requests that the information not be released. So if you don't have that law enforcement request, even if you think that the parent's an abuser, this statute does not allow you to deny access to the parent. It's quite problematic. Well, what about if there's another federal law out there? Does federal law preempt the disclosure? For example, HIPAA. I'm going to come back to HIPAA in just a second. What about substance use disorder regulations? Well, those would presumably trump, but you have to make sure that you understand the limits of those substance use disorder regulations when information can and cannot be disclosed to the parent. The rules under the 42 CFR Part 2 differ depending on whether or not the minor can consent to their own health care. Generally, as in Idaho now, that the minor cannot consent to their own health care, the rule is that if a minor shows up and requests treatment, you cannot disclose the kids, the minor's request for treatment, but neither can you go ahead and provide the treatment based on the minor's care. So basically, you can't disclose that the minor requested the treatment, but if the minor refuses to allow you to disclose that to the parent, then you can't provide the care to the minor. Therefore, you wouldn't have any other records there. So make sure that you're aware of those in the substance use disorder situation. Now, note that those regulations only applies to federally assisted programs that provide substance use disorder treatment. It's not all healthcare providers. It's only those who are federally assisted programs within the meaning of 42 CFR Part 2. But what about Title 10 programs? Again, HHS has taken the position for a long time that minors who receive care from a Title 10 program grantee, that their information is confidential and the parents don't have a right to access it. But that seems to have been overturned now by that Fifth Circuit case. So in all likelihood, that's probably not where that's going to end up. We'll have to see what the U.S. Supreme Court says about that. What about the information blocking rules that generally prohibit you from denying access, but create certain exceptions, including the preventing harm? We'll talk more about that in just a minute. The big one, though, is probably HIPAA. So does HIPAA trump the Idaho statute? Because remember, under HIPAA, it currently allows you to decline to treat the parent as the personal representative and or disclose information to the parent under certain limited circumstances. HIPAA says in the section dealing with personal representatives, if and to the extent permitted or required by an applicable provision of state law, a covered entity may disclose or provide access in accordance with 45 CFR 164.524, that parent access or the patient access regulation, to protected health information about an unemancipated minor to a parent, guardian, or other person acting in loco parentis. But note there, so it basically says, hey, if the state law allows you to make disclosure to the parent, then you can go ahead and make it to the parent, so long as it's in accordance with 45 CFR 164.524. Well, what does that mean? Because under 45 CFR 164.524, there are a lot of situations or limited situations where you can refuse to disclose information to the parent and by extension to the personal representative. For example, you can refuse to disclose information if the information is outside the patient's designated record set. Also, if it's psychotherapy notes, which is a very, very limited set of notes. There's limits on disclosures to correctional institutions. You can decline to provide information. A correctional institution can decline to provide information to the patient or their parents if it would jeopardize safety for certain research purposes. If the information was obtained under a promise of confidentiality and disclosure would reveal the source of the information, then 164.524 under HIPAA would allow you to decline to provide that information to the patient and by extension their personal representatives. The one that's most important is there's the exception that if a licensed provider determines that disclosure is reasonably likely to endanger the life or physical safety of the individual or the other person, then you can decline to provide that information. Under that last one, it is subject to review. The patient has a right to have that decision reviewed. So these are exceptions. These are situations, at least under HIPAA, where you could decline to disclose information to the patient and by extension to the parent. But the question is, does this preempt Idaho law, or does Idaho law control this particular situation? We'll come to that in just a minute, maybe. There's a separate section of HIPAA allows you to decline to treat the parent as the personal representative under limited circumstances. Under HIPAA, you generally have to treat the personal representative as if they were the patient. That means they can access the patient's information. But a personal representative is the person who's got authority under state law to go ahead and make healthcare decisions for the individual. But there's certain circumstances that would allow you to refuse to treat the person as the personal representative. One exemption is, I don't have it up here, but if the parent agrees that to provide care and to maintain the confidentiality, then under HIPAA, you can refuse to disclose that information to the parent. Another exception states that it's basically the substantial harm to the patient exception. States that notwithstanding the state law or any requirement of this paragraph to the contrary, a covered entity may elect not to treat a person as the personal representative, meaning that you don't have to disclose the information to the parent, if the covered entity has a reasonable belief that the individual has been or may be subject to domestic violence, abuse, or neglect by such person, or treating such person as the personal representative could endanger the individual, and the covered entity in the exercise of professional judgment decides that it is not in the best interest of the individual to treat the person as the individual's personal representative. Now, note here that it says notwithstanding the state law or any requirement of this paragraph to the contrary. Here we've got a contrary state law that says that you must provide the parent access. This seems to say that notwithstanding that state law, that you could refuse to treat the parent as the personal representative and refuse to grant them access if you believe it's not in the patient's best interests and you otherwise think that it could endanger the individual. Well, that makes it seem like this preempts the Idaho statute if that applies. However, you go back and you look at the statutes, the HIPAA provisions that talk about preemption. And for example, one of them states that nothing in the HIPAA privacy rule may be construed to preempt any state law to the extent it authorizes or prohibits a disclosure of protected health information about a minor to a parent, guardian, or person acting in loco parentis of such minor. That seems to suggest that it does not preempt the Idaho law because the Idaho law authorizes the parent to access information. The commentary that accompanied that rule states that this rule does not affect parental notification laws that permit or require disclosure of protected health information to a parent. The bottom line here is, despite what those HIPAA provisions say, I've got to assume that because of this, when they passed HIPAA, they didn't want to buck patient parental access laws, and therefore the HIPAA provisions do not preempt parental access provisions. But the language is a little bit fuzzy. We're just going to have to wait and see how these things play out. All right. A new twist on this is the new rule that just came out on HIPAA and reproductive rights. This just is hot off the presses. It came out yesterday. We got the notice of this. This new rule is very limited. It basically says that a covered entity may not use or disclose protected health information if somebody shows up and wants that information to investigate or impose civil, criminal, or administrative liability to individuals. Generally, you can't disclose that information, and you've got to get an affidavit from somebody if they're seeking information to confirm whether or not they're disclosing this information. Now, this new rule takes effect 240 days after the date it's published. It'll probably be published in a week or two, so it takes effect excuse me, it becomes effective 60 days after then, but it's not going to be enforced for 240 days after that. It's a very narrow exception, so it's probably not going to apply to most of you. But what interested me was the commentary that accompanied this rule. A couple of quotes from that seem to touch on this HIPAA preemption issue. For example, in one situation, it says this final rule does not interfere with the ability of states to define the nature of the relationship between a minor or parent or guardian, so it doesn't affect the minor consent issues. It also says under this final rule, a regulated entity is prohibited from using or disclosing a minor's PHI for purposes prohibited by the rule. The privacy rule generally permits a parent to have access to medical records about their child as their minor child's personal representative when such access is consistent with state or other law, which is Idaho law allows the parents to have access, right? But this commentary says with limited exceptions, and then it refers back to those two provisions, the limits on patient and parent access under 0.524 and the limits on the exceptions that would allow you to not treat the parent as if they were the personal representative in the endangerment situations under 164.502. So what does that mean? Does that mean now that HHS is taking a different view on this, so that if you fit within one of those exceptions, that it trumps contrary state notification laws? Again, we don't know. We're going to have to see how that plays out. But I think in the meantime, I think you should assume that parents should have access. If you're not going to give the parents access, just realize that you're doing that at your risk. I received a question about the information blocking rule. Does it somehow preempt this state statute? Because as you know, under the information blocking rule, it prohibits healthcare providers and certain other actors from placing unreasonable access to electronic protected health information. So you generally can't prohibit parents or other people, if they're authorized under appropriate law, to access that information. But there is an exception under the information blocking rule to prevent harm. But in order to fit that prevent harm exception, there's a bunch of stuff that needs to be satisfied. The bottom line is we don't know whether that's intended to preempt all parental access rules or not. Again, it's kind of like the HIPAA stuff. We're just going to have to see how that plays out. We're still trying to work our way through those things. All right, although this isn't in the new law, I did want to point this out. What happens if you have one parent, you want to disclose information to one parent, but that parent tells you not to disclose information to the other parent? Well, in Idaho, we've had a law in the books for a long time, which says that notwithstanding any other provisions of law, access to records and information pertaining to a minor child, including but not limited to medical records, shall not be denied to a parent because the parent is not the child's custodial parent. So just because a parent is not the custodial parent doesn't mean that they can't access the child's records. They would still have a right to go ahead and do that. All right, that is the parental access issue. I wish we had more clarity on those substantial harm factors, but I think given that preemption language that currently exists in the rules, I think you've got to assume that they do not preempt the Idaho access statute. So what happens if you violate this? The statute says any parent who is deprived of a right as a result of the violation of this section shall have a private right of action against the individual healthcare provider or governmental entity. They can sue you. And a parent who successfully asserts a claim or defense under this section may recover declaratory relief, meaning they get an injunction so that they can, tells you to give over those records. Any compensatory damages, I'm not sure what compensatory damages they would be able to establish. There is not a minimum or a statutory set there, but presumably they could recover compensatory damages. But they can also recover their civil attorney's fees and any other relief available under law. So once again, they've made, given parents, kind of like in the abortion context, they've given them the chance to, or the right to sue you for violations of these particular statutes. One interesting twist on this, note that it says any parent who's deprived of this right. So what happens if you get consent from one parent, but not the other parent? Well, you didn't get the consent from the one parent, the parent you didn't get the consent from, can they sue you? Well, under this statute, it seems like it, but I doubt it because you haven't violated the statute if you got the consent from one parent, because you're only required to get the consent from one parent. But again, just goes to show kind of what happens when you get sloppy drafting that's kind of rushed through without people having a chance to vet it. For you who are governmental entities, it is subject to the Tort Claims Act, so they'd have to jump through the Tort Claims Act hoops. For those of you who are not governmental entities, that doesn't make a difference to you. There is a 2-year statute of limitations on this private cause of action. All right, so that's the law. It takes effect July 1st, 2024. What do you need to do before then? Well, I think you need to start educating your minor parents or patients. Let them know that effective July 1st, you can't continue to provide care to them without parental consent. Not only that, but they need to understand that their information is presumably not going to be confidential come July 1st. You're going to want to update your consent forms, policies, and practices to ensure that you're compliant with that and you're getting parental consent. You're going to want to update your medical records, forms, and policies and practices to ensure you're compliant with parental access issues, including your HIPAA policies concerning parental access, the exceptions and the like. You're probably going to want to review and, if necessary, update your HIPAA notice of privacy practices to reflect the Act's requirements, because remember, on one of the requirements for your notice of privacy practices states something to the effect that if you have a more restrictive state law, then you need to make sure that that is reflected in your notice of privacy practices. Just make sure your notice of privacy practices is consistent with that, and it's not guaranteeing minors confidentiality that they do not have. You're going to probably want to update your patient portal policies or access rights, because in the past, you probably denied parents access to the kids' records. Well, that may not be appropriate going forward. You're going to want to train personnel concerning the new rules, policies, and practices. You're going to want to discuss the potential for lawsuits with your insurance broker to make sure that you've got coverage for this new cause of action that may be asserted against you. And I'm sure that there are other things that need to be worked out, but that was kind of my quick list, checklist of the things that need to do. All right, so there are the rules. I see that I did get a couple of questions coming on the chat line. I think I've got time to go ahead and address some of those. For those of you who don't want to stick around, you're welcome to jump off. One question was, how does pregnancy apply to emancipation? I think I addressed that. Under Idaho law, pregnancy is not an emancipating event. I think that's the only way that you can address that. I think that's consistent with the Dobbs decision also. They seem to recognize that there is no constitutional right necessarily that just because you're pregnant that you have a constitutional right of privacy or the like. So given the current state of the law, I think the assumption is pregnancy is not an emancipating event. Next question. What about multiple procedures? Will multiple consents needed for all elements of L&D care? That's a good question. Generally, you could probably get a blanket consent, and I think that that would be probably sufficient, but that blanket consent you would want to make sure was sufficiently informed, that it addressed the reasonably foreseeable risks and the benefits. If something comes up that's kind of outside that blanket consent, then I definitely want to get a new consent from the parent to make sure that that's covered. What about, next question was, what about records for care provided in Washington or other states which do allow for minor consent? Does this Idaho law take precedence over the other states? Good question. I'm not sure exactly how that would play out, but since you are governed by Idaho law, if you were in Idaho, then presumably that Washington parent could go ahead and provide care. As far as a Washington minor coming across to see you, if that Washington's in Idaho, then Idaho law is probably going to apply, and I'd be very careful about providing care without the parental consent. If you're providing telehealth services, if the patient's in Washington and they're a minor there, you're probably going to be okay. But if they're coming over across the border into Idaho, then I think that there is a risk. It's not clear, the minor may not, or the parents may not sue you, but if they chose to do so, you would be violating Idaho law on that particular issue. Would a blanket consent that includes contraceptive, sexually transmitted diseases, treatment, and substance use disorders specifically be adequate? I think probably it would. I think I would refer back to the specific statute. And when I draft these blanket consents, I think I'm going to start making a reference that this constitutes a blanket consent pursuant to Idaho Code 32-1015. But again, you're going to want to make sure that whatever you put in that blanket consent has sufficient information, so there's no dispute as to what the patient or the parent is consenting to in the scope of that blanket consent. Next question, how do we ensure the adult consenting is the biological parent? How do we prove this? Is it sufficient to have them sign a form attesting this? That's just going to come down to a matter of proof, right? That's really no different than the way it has been for years and years and years. I think there's ever a question about it, as long as you are taking reasonable steps. For example, for a long time under HIPAA, you've got an obligation to verify that they are who they are. But that would be things like asking for, photo ID, maybe asking for data, asking them to identify the child's date of birth or some other information like that. As long as you're taking reasonable steps and probably documenting that, I think you'll probably be okay. All right, that is it. Best of luck as you move forward with this. We'll try to keep you updated as we get new developments along those lines. Otherwise, we appreciate your participation. If you have other questions that you'd like to send to me via offline, I'll try to respond to those as I'm able. Thanks very much. Hope you have a good day.